SJC-13324, Commonwealth versus Luis Gomez.
Attorney McDonough.
Good morning, Your Honors. May it please the Court. My name is Jaleese McDonough, and I represent Mr. Luis Gomez. Almost the entirety of the evidence presented at trial was video evidence, and the sole issue before the jury was whether the person depicted on the grainy, unclear video shooting at Mr. Flores was Mr. Gomez. The video was too unclear for the jury to determine beyond a reasonable doubt that the shooter was Mr. Gomez. And the Commonwealth usurped the role of the jury through both its argument and testimony and essentially took that issue away from the jury.
Well, that's not all they had. They also had the statement of Mr. Nieves where he identified the shooter and the Commonwealth cobbled together and said, here's the video and Mr. Nieves' statement that here's the guy. They have similar clothing to the video surveillance of who you at trial at least conceded was Mr. Gomez inside the club. So there's more evidence of identity. You may not like it, but there was more than just the video.
So Mr. Nieves does identify on the actual video of the shooter who the shooter was in the video. He doesn't ever identify who that person is.
I
so
agree.
he's shown
but there are inferences and there are different facts that the jury could put together and say that's who, beyond a reasonable doubt, shot Mr. Gomez.
Well, Mr. Nieves is shown an actual photograph of Mr. Gomez in the club, who the defense concedes is Mr. Gomez, and he's unable to make an identification of the person who they believe is Mr. Gomez as the shooter. Mr. Nieves describes the shooter as wearing a gray sweatshirt, which undercuts the Commonwealth's argument that the person was Mr. Gomez, who is clearly wearing a blue sweatshirt within the club. And they do use pieces of video to try and piece together that this is Mr. Gomez in the club. But our contention is that it doesn't get them to that point. The first clip that they use, there's essentially 3 clips that they piece together. So they have the arrival video, they have the video inside the club, and then they have the actual video of the shooting. Even the initial video of the arrival, that's never even established that that's Mr. Gomez. And they use portions of that video to compare to the shooter to try and argue that that's Mr. Gomez. So the white sneakers, you cannot see the white sneakers inside the club, or at least the sole of the shoe. And even to get to the point of piecing together these 3 separate clips of video, you have to pile inference upon inference, and you have to speculate that the initial person is in fact Mr. Gomez. And the Commonwealth kind of recast our argument as we're saying that this court doesn't have to draw all reasonable inferences in support of the Commonwealth. But the point we're trying to make is there's one clip inside the video, inside the club by Mr. Creswell that shows portions of the club. At least 7 or 8 people are wearing the exact same items of clothing that the Commonwealth asks the jury to compare to conclude that it's Mr. Gomez. So it's
all are 7 or 8 with the other gentleman with the distinctive clothing?
They are. They're all standing in a line. So they're all standing in a line watching the performers. There's at least 6 or 7, and then the performers themselves also are wearing the same items, but it's the hat with the emblem, with the reflective sticker, and a sweatshirt. The distinctive items that are on Mr. Gomez are the giant owl tattoo, the emblem on the side of the hat, and the strings. None of those 3 items can be seen on the shooter. So
the shooter is seen next to the gentleman with the red, white, and blue.
So he is seen next to him, but I think for one, this court has said time and time again that mere association does not establish proof beyond a reasonable doubt. That he's with this other person doesn't establish that it's him. There's 3 people who arrive at the club together, one of which is the guy in the red and white jacket, another which also has a sweatshirt on and a hat with an emblem. And also, the video that shows the shooting, it cuts off. It shows just the kind of going down the street and then the shooting itself. The whole front of the club you cannot see, and then you see people disperse after. So it's clear there's more than one person there. And Mr. Neves himself says it's kind of a chaotic scene. There's a lot of people outside. So I think just the...
May I ask, wasn't there also testimony that Mr. Gomez was left-handed?
There was testimony that he was left-handed and the shooter used their right hand when they were firing the weapon.
But the gun wasn't also testimony, at least from Mr. Niev's statement, that the shooter wrapped the gun with the left hand.
There was, but I think a fair inference would be that the person would use their dominant hand to shoot, not necessarily rack. You have to use one hand to do one and one in the other, but I think typically people shoot with their dominant hand, don't rack with their dominant hand. So I think that was the point counsel was trying to make in eliciting that Mr. Gomez is a left-handed individual. And so I would like to move to the next point. In addition to the insufficiency, given that we do have a case where the main issue before the jury is whether this one person on the video is the shooter, the Commonwealth usurped that role through both its argument and the testimony. And just at the outset, I would acknowledge Mr. Riggins did not specifically say the shooter, it's my opinion, the shooter is Mr. Gomez. He didn't even go as far as to say this piece of clothing matches this piece of clothing.
Which is different from Wadsworth, correct?
It is different. I think it's a little closer to maybe Robertson. He did say right hand, left hand in Robertson, but I think taking everything in combination, we go past that line that this court said in Robertson was very close to the line. So we do have, at the outset, the Commonwealth opens by saying the Springfield police, through Riggins, pieced together all of this video. He took items of clothing. He went through each item of clothing, the hat, the emblem, the strings, the sneakers, and then said that we pieced together the video from beginning to end, and it led us to Mr. Gomes in the club with the owl neck tattoo. Then we have Mr. Riggins who gets up, and I would just point out at this point, there was another problematic part of the testimony. Throughout, the prosecutor says they. He pieces together, he combines essentially Riggins with the Springfield police. He says they pieced together the video. They did all this. The Springfield police, through their good detective work, did this. And then Riggins says we did this. And taking this in combination with Detective Krogan's testimony makes it even more problematic. So we have Riggins saying, I took these little pieces, I matched the clothing, and I pieced together all of the video. He put circles around who we were watching. And then he says that they pieced together to figure out who the shooter is. And then we go to Detective Krogan, who says that they received a description from Mr. Flores of a blue sweatshirt, which was incorrect. It was actually a blue shirt, which was corrected, but it was before the jury. Blue shirt, blue hat. Then we pieced together and looked back and found who we were focused on. And then in closing, the prosecutor again says, the Springfield police, Mr. Riggins, pieced together all of this video. They matched clothing, and he went through each piece of clothing. So we have not only just Mr. Riggins saying he put this video together, but we essentially have the Commonwealth saying that the Springfield police, they got this description from Flores, which was not even really substantive evidence. We've targeted a person, and then we pieced together the evidence to come to the shooting. So all of this taken together was essentially an opinion that all these clothing items matched, that this person was Mr. Gomez, that they received a description of a blue shirt, a blue hat.
And you're tethering this to the compilation video?
Yes.
And admission of the compilation video?
Yes, Your
Okay,
Honor.
but can you also, when you're going through this though, grapple with the fact that Judge Wilkins gave a really strong limiting instruction to the jury, and where it said you don't have to accept any of this. It's still ultimately your decision.
I agree that he did give a very strong limiting instruction, but I would ask Your Honor to also look at the instruction that he gave during Detective Krogan's testimony. When Detective Krogan testified that Mr. Flores said that the shooter was wearing a blue shirt and a blue hat. He then instructed the jury that they could use this evidence to determine why the police took certain steps. So now we have him instructing that Detective Krogan took all of these steps because of the
That's
I think, I agree with you, Your Honor, but I think when we take it in its totality, I think it undercuts the argument, the instruction that he had given that they should make their own determination, because now we have...
This goes to why the police pursued a particular angle. It's Bowden.
This is your Bowden issue.
It is, but I think...
Wait, hold on. You're asking us to take something that Judge Wilkins allowed the Commonwealth to introduce as a result of something the defense did on cross-examination with defense. No, because there was also the testimony, the cross-examination of Detective Krogan. So it wasn't just opening statement. There was another reason why that the judge allowed the Commonwealth to introduce that statement from Mr. Gomez. But irrespective of whether it was the cross-examination or the opening statement, it was Judge Wilkins' response to what he perceived the Commonwealth opened the door to. So now we're going to have to take that allowable response to that issue and meld it to the other issue of the compilation?
I can make 2 points. I think the point I'm trying to make is that it couldn't have been undone by Judge Wilkins' instruction, because we have a case where the evidence wasn't overwhelming. We have the video is the sole evidence that the jury has to look at to determine whether it's Mr. Gomez. And then all of these prejudicial points as to opinion evidence as to openings and closings, and Riggins and Krogan, all taken together didn't overcome Judge Wilkins' instruction to the jury. And then as to your point...
but you agree that Judge Wilkins' instruction was proper?
Yes, it was. And as to the second point with Detective Krogan's cross-examination, that occurred after Judge Wilkins already made his ruling that the defense had opened the door during opening statements. So on the 7th day of trial, the Commonwealth came forward. They lost on the dying declaration rationale, and they said, well, now we're offering that the defense opening opened the door. So now we want to use it in rebuttal to Bowden. Judge Wilkins agreed. So at this point, defense counsel said, well, I didn't question any of these witnesses as to a Bowden defense. I didn't question Officer Ruffalette even about the dying declaration. So now it's coming before through 2 layers of hearsay. And then Judge Wilkins did also point to the fact that defense counsel put in the photograph.
But it wasn't hearsay. It didn't come in for its truth.
It didn't come in for its truth. But I misspoke. He didn't get to question the person who actually received the statement from Mr. Flores to anyway undermine it. But at that point, he had not asked one witness any questions that bore on a Bowden defense. It wasn't until after Judge Wilkins then determined that it opened the door. Detective Krogan testified on direct that Mr. Flores gave this description of a person in a blue hat and a blue sweatshirt, that he then went on to ask some questions both about that statement and then a few questions about the investigation that I would submit weren't even really that strong. It was about cigarette butts that were allegedly found, whether they tested the cigarette butts, and a couple of other questions that bore on whether what they did.
You may, I'm sure you know the record much better than I, but even in your presentation here, you made reference to the fact that the clothing that Mr. Gomez was wearing that night was gray. But what is the judge to do when they make that same opening statement and reference the fact that, hey, they're chasing somebody or they're chasing our guy and our guy's not even wearing the same clothing? What is the judge to do with that? How is that not opening the door? Well,
our alternate argument, if this court finds that it did open the door, was that counsel was ineffective in attacking the investigation, a wholesale attack, when he could have simply just noted for the jury that, we have this description given by the witness of a gray sweatshirt, and we have Mr. Gomez, you can see what he's wearing here.
There was no motion for new trial on that ground.
There is not, but I think we can assume that it was a strategic decision, which is, I think, is what we would...
You know our case law about the impact of a allegation of ineffective assistance without a motion for new trial?
I do, Your Honor, but I think the case law is clear that the main issue we have to determine typically in a motion for new trial is whether the decision was strategic. I think Commonwealth versus Wright also says that the standard for ineffective and whether the court made a proper ruling would be the same at this level. So if we were to assume that the decision was strategic, that he wanted to emphasize for the jury that the one eyewitness described a gray sweatshirt and then Mr. Gomez was clearly wearing blue. I think it's apparent from the record that that's the point he was trying to get across. There was the decision to then do a wholesale attack on the investigation was not reasonable, where he could have achieved the same point without opening the door to the one piece of evidence, even though it was only for the steps in the investigation, but the one piece of evidence where someone said the shooter was wearing a blue shirt and a blue hat, which is exactly what Mr. Gomez was wearing in the club, which is exactly what the defense counsel even conceded was Mr. Gomez in the club. And the other individuals, I'll note, that were standing that had the sweatshirt and the hat were all wearing red. So the grayscale video, yes, it could have been any one of these individuals, but now we have one statement where they're claiming that the person was actually wearing a blue hat and a blue shirt.
Can I turn you to the thing that actually is giving me the most heartburn, which is the lowering of the verdict? Is there any case like this where what's the best case that justifies the lowering of a verdict? Say you don't win on, and you've done a very good job of presenting the evidentiary issues, but the sufficiency issues. But what if you don't win here? I just don't see how the judge could possibly lower the verdict here, given the conduct here. So help me out and tell me what cases I should look at that supports this.
I think that the strongest case for our position would be Commonwealth versus Gee, G-H-E-E, which I cite in my reply brief. This court found that there was slim evidence of deliberate premeditation, even where the defendant shot his girlfriend in their apartment with a sawed-off shotgun, and he had beaten her up 3 weeks prior. So there was this evidence that she was shot, because the Commonwealth's argument is essentially premised on this court basically finding there's a conclusive presumption of first-degree murder if someone uses a firearm and shoots at someone. And I don't think the case law supports that. I think this court said...
But this is still, when you think about what the theory was, that's in the light most favorable to you. The Commonwealth's theory is there is this beef with Mr. Gomez I forget, unfortunately, the decedent. Mr. Flores. And whether it's with Mr. Gomez or his friend, that Mr. Gomez then goes to and this is what the compilation video underscores. Mr. Gomez gets a gun and comes back and essentially brings a gun to a knife fight. And Mr. Nieves adds color to what happens in his statement, that this fellow is trying to diffuse. Back to Justice Kafker's point, we get to see the video too, and I looked at the video and I'm stunned at how, I'm really stunned at how Judge Wilkins can make these conclusions with what's on that video. That video shows, and that is Mr. Nieves walks us through the interview with the police. He testifies, or at least gives a statement, that the decedent is trying to diffuse the situation. At one point, Mr. Nieves puts his hands on the decedent, tries to pull him away, and he then says, the shooter racks the gun, and I back away. And then you look at the video, at whether the compilation or the independent video from the police. That gun is pulled out, and when that gun is pulled out, the decedent backs up, has his hand up, and you can count 6 or 7 seconds before there's a fire to his abdomen. How is it that you can say the jury could not find an intent to kill? So, Your Honor, I think that's applying the Lattimore standard, which this court has said the Lattimore standard is... I'm looking at an abuse of discretion standard and to lowering the culpability here. Yes, Your Honor. That's what I'm looking at. How is it that you could say that on those facts, that somehow the jury could not find an intent to kill.
I don't think the standard is that they could not find. I think that's the Lattimore standard, which this court has said does not apply to a reduction in verdict. For a reduction in verdict, the standard is whether the evidence, even if sufficient, the reduction of the verdict is more consonant with justice. And the factors that he looks to, and he doesn't explicitly cite Colleran, but he does touch on the factors that this court has said are relevant under Colleran. He looks to the fact that the shooter had a sort of unmitigated rage. He had this altercation in the club. He came out.
Hold on for a second. But how is it that Judge Wilkins gets to make that determination? That there's unmitigated rage? Because we can see the video. This isn't just a shooter just spraying 7 or 8 shots. This is a gun gets pulled out, racked. There's an amount of time that goes by, a few seconds, which is probably a few hours in that circumstance. Mr. Nieves backs away, and then there is a shot directly at the decedent in his midsection. Where's this that Judge Wilkins gets to say, here's what I think is going on?
So I think, if I can make 2 points, that Mr. Nieves does say that the shooter is enraged, which supports, I think, Judge Wilkins' finding that there was sort of this unmitigated rage. There's also, inside the club, you can see that there's an altercation that occurs.
It says that the shooter was bugging out. He was angry at somebody in there. Okay, there's nothing that supports this unmitigated rage.
I think there is, Your Honor. I think there's this fight inside the club. The individual comes out of the club. Mr. Nieves says that the person's enraged. He's angry. He's asking, where's your car? Do you have a car here? He's yelling at him. And as far as the pause between when the firearm is racked and when Mr. Flores holds his stomach, I think it's clear from the video that that wasn't the first shot, the shot to the abdomen. He was also hit in the knee, and there's a number of casings that are found on the ground.
Sure.
I think the inference, given that he holds his abdomen and turns, is that that's the last shot. So,
how is that a reasonable inference that the jury had to have made, and they couldn't have just said, that's an intent to kill? This is a really outstanding decision, in my view, that Judge Wilkins does here.
Well, Your Honor, I would emphasize again that it's not whether in the light most favorable to the Commonwealth there's evidence that can support a first-degree murder conviction. It's whether the evidence, even if sufficient, the trial judge who saw the witnesses, who viewed the testimony, determines that a lower verdict is more consonant with justice.
So it has to do with the premeditation component. Right?
Yes, Your Honor.
But I think Justice Georges is asking you, what's the limiting factor if a trial judge can say, well, I don't think there's enough premeditation, it's not consonant with justice. I mean, we don't say that premeditation is based upon, assassinations. And I get your point, some of the case law that talks about these brawls, nonsensical brawls, with rage, may not rise to premeditation, but here we have a person who's upset at the doorman and empties a clip into him. So how's that not consonant with justice?
So the points that Judge Wilkins relies on are the fact that the shooter was extremely angry, didn't seem to have any direction towards Flores, was trying to just get him out of his way to deal with the people inside that he did have a fight with. He also points to the fact that even though the Commonwealth speculates that the person went and retrieved a firearm from the van, that was to get back at the people who were inside, and he became enraged with Mr. Flores, which Mr. Nieves did say that Mr. Flores was attempting to stop the shooter from going into the building. He became enraged, that he shot downward towards the individual's feet. It wasn't kind of a shot to kill on the upper extremities.
That seems nonsensical to me, that we're going to count ballistics marksmanship on premeditation. That unless it's a tight grouping by a Navy SEAL, it's not premeditation. That seems absurd to me.
Well, I don't think we have to conclusively establish that just because someone uses a firearm and shoots in someone's direction that it's automatically deliberate premeditation or intent to kill. I think he took all of these factors into account, that the person did seem enraged. The Commonwealth suggests there's no evidence of alcohol. I think there was actually, if you take that the person who arrived was Mr. Gomez and the person in the club is Mr. Gomez, he's seen drinking throughout the night.
We don't know what was in that cup.
Well, there's a beer in the...
The only statement that talked about drinking was Mr. Niev saying, hey, I'm not gonna lie, we were drinking. But again, I just don't know how this all fits in premeditation, that somehow this seems exactly what we say you don't use this rule for, that it's to be used sparingly. And this is not a substituted judgment standard. And it seems like that's what's going on here.
I don't think it was a substituted judgment. I think Judge Wilkins looked at the testimony. This was obviously something that was concerned him. He was the one who issued the order indicating that he was retiring and was soliciting that if you're going to file this, I'm retiring. So obviously it had given him pause even at the time of trial. And Mr. Flores, he died during surgery. He didn't die as a result, at least, initially, as a result of the gunshot wounds. He was in surgery. He lived for 10 days and then passed away.
May I just ask you one thing, because it melds two different issues that I want to, you were talking about strategic decisions by defense counsel. So one of the things that the Commonwealth quibbles with, and you say the judge is not doing on the 25B component, is essentially trying the defendant's case, saying that, hey, they didn't put in evidence because the defense's entire theory was he didn't do it, right? But the defense could have argued in the alternative, couldn't they? They could have argued, hey, my guy didn't do it, and even if you think he did it, he certainly didn't do this. It's not first-degree murder, right? They could have done that.
I'm sure he could have done that, but I think that
that's important for me to say that, for you to concede that, though, because you say the Commonwealth is wrong that Judge Wilkins is using the 25B tool and importing other things outside of essentially the record. And isn't that doing that? Saying, hey, if they had tried a different case, they might have adduced different evidence. Isn't that exactly what he's doing?
I think I would take the position that was more of kind of dicta in his decision. I don't think it was the gravamen of why he reached the conclusion that the reduction was more consonant with justice. I think he more so relied on the fact that of the other factors in Colleran as to why he felt it pointed more towards second-degree murder. And he does say that it may be under the case law, it's sufficient to find first-degree murder. But in my position as the trial judge, viewing everything, I believe that second-degree murder was the stronger determination. So he does mention that defense counsel didn't pursue a second, but I don't think his decision in any way rested on it where it would be considered an abuse of discretion. And I think that he acknowledges Tejeda, he acknowledges all of these cases that say you can find that there's deliberate premeditation, you can find a lethal intent if someone shoots and kills, but I'm not required to say that, or a jury's not required to say that that's a conclusive presumption. And all of these factors, the fact that he didn't pursue the victim who was shooting down, he seemed to be enraged, all, I believe, point to a lower verdict. And we would find that we would ask that you use the strong deference towards the trial judge and uphold that decision.
Is he owed any deference here when we have the video ourselves and we can see for ourselves?
There is one case that says that the trial judge is in a better position and deference should be owed to the trial judge. I cite it in my reply brief, Your Honor.
Thank you, counsel.
Okay, thank you very much.
Attorney Lynch?
Morning, may it please the court. Travis Lynch on behalf of the Commonwealth, asking the court to reinstate the jury's verdict of first-degree murder with deliberate premeditation, and otherwise asking the court to affirm the balance of the judgment. Starting with, just to address briefly the defendant's issues on appeal, just on the sufficiency of the evidence, clearly the same person in the light most favorable to the Commonwealth. I'd point, you can see at various stages in the video outside of the club. You can see the sticker on the hat that's in the same place that you can see that there's a sticker on the defendant's hat when he's inside of the club. I'd also note that, again, we have Mr. Nieves pointing out the shooter in the video that he's watching in his statement. We also have testimony that says the defendant is not at the club when the police do a sweep afterwards. So he's gone afterwards. So it's not simply the case. I mean, the video is exceptionally important, but I don't think it's quite right to say that that's the only evidence here.
Counsel, just one thing on the identity. We also have the testimony of the woman who the decedent came up to and said, "Help, help," because wasn't there testimony that the white van came up the street and hit her car?
That's right. There's also that.
Okay.
So that would all, I mean, again, it's not just the video, but your point's well taken. On the
Counsel, can I back you up a second? Because there are so many stickers visible in the footage from inside the club.
Right.
Are you arguing, and was there any, well, I guess there wasn't discussion of this below, but are you arguing that the sticker is distinctive in any particular way, or that the sticker is different from the other stickers that are visible, or that it has a particular shape that's different? Was any of that, I don't remember any of that being argued in closing.
No, I think the sticker is on the same part of the brim of the hat. I think
The top of the hat where all the other stickers were.
Well, when you look at the video, it looks like it's at the same location. When you compare the exterior video and the interior video, the sticker appears to be in the same location. There's also the yelling guy with the windbreaker, that's clearly the same person in the grayscale and in the interior video. So it's not guilt by association. It's just he seems to be with this other fellow. And Nieves does identify the yelling guy as wearing the red, white, and blue windbreaker. There are other clothing items that I think you can see at various points in the video that's not immediately apparent from the still shots of the surveillance that defense has put in their brief.
Yeah, on the, is there anything you want to say about the part of the video, I've watched the videos, anything you want to say about the part of the video that ostensibly shows the sort of fight inside, or the altercation inside the club? Because I found that really hard to understand.
I also found that. I agree that was difficult to understand, but I don't know what else to say.
I mean, the most that possibly can be said is that it's clear that there was some sort of activity in there.
Yes,
That was happening. But I don't know, do you argue that there's anything more than can be said, that there's movement of people?
You can see the defendant leaving with the windbreaker guy, but other than, I don't think if there was a fight, who knows? I have no idea what happened, but there was some sort of disagreement that causes this movement, and then the defendant goes outside. But other than that, I don't particularly recall.
I think if I may, because I had the same question of Justice Stewart, because one of the reasons why it was important to me, or at least I was trying to figure out, was Judge Wilkins makes a determination that the defendant could have been bringing the gun back to address an altercation with another individual in the club. And it just seemed to me that that was all congregated by the front door, where the decedent was the doorman.
That's right.
So how could you, I just was trying to figure out how could you conclude that you're going back to address some other unrelated person where it could very well have been. I just don't know. I
think part of that comes from Nieves' statement,
Yeah.
because Nieves gives you that there's some sort of disagreement. Right.
Inside, but he doesn't say it wasn't with the doorman, is what I'm getting.
Oh, no, I don't.
That's what I'm getting at.
Right, I don't think that the defendant's problem originally was with Flores. I think Flores just got in his way.
Okay.
But that's
Flores
based on the Nieves testimony, not the video.
Right.
So the Judge Wilkins is right to emphasize that he doesn't go back to get the gun to shoot the victim, but rather to get the gun for the fight with the other guy.
So our point is, It doesn't make any sense to give the defendant a discount here because he killed someone on his way to go get into a fight with someone else. It doesn't particularly, I mean, the doorman is doing his job to prevent people from getting it back into the club without being frisked. There's testimony about that, so he's there for security. The fact that he then decides to fight with a security person and shoot him to death doesn't mean that he lacks deliberate premeditation and intent to kill vis-a-vis our victim. We don't really know who he had a beef with inside of the club. It doesn't matter. The fact is, he leaves, he wants to shoot someone, and then he comes back, and then he shoots Mr. Flores because he's mad because he won't let him back into the club. That's deliberate premeditation. And Justice George was saying it very well earlier when he's standing there for several seconds. He has come back to his van. He gets a gun. He encounters an obstacle. He racks the slide.
How do you reconcile that with our case law that says basically if you have an inexplicable brawl with no prior relationship between the victim and the defendant, and the defendant is essentially a hothead and shoots someone, don't we have case law that says that that's, in the interest of justice, reducible to second degree?
Occasionally, but you'd be like a minor controversy exploding into the killing of the human being. Even in some cases, like I believe I said Fernandez, even in a case where that is present, it's not necessarily a reason to reduce the verdict. It can be a factor to consider, but
this has to do with whether or not there was an abuse of discretion by the trial judge, right?
right,
And whether or not the trial judge erred in saying this was not consonant with justice.
right. But I'm not sure that that was really what, like he doesn't articulate it quite in those terms. He seems to be concerned with, I mean, a large part of our argument on appeal is that the judge doesn't seem to agree with the inference or with the law that shooting a human being at close range is powerful evidence of intent to kill. He doesn't seem to believe
Well,
that.
intent to kill is, I mean, obviously you have it from the use of a deadly weapon, there's an inference of intent to kill. I don't think intent to kill is really the issue here. The issue is premeditation. If it was an intent to kill,
But he says that he doesn't agree with that as to intent to kill. And in the same breath, he practically says, and I also think that the fact that he's shooting wildly undermines deliberate premeditation. But like you just said, there's no poor marksmanship discount here. He's shooting at Flores. He means to kill him, and as he racks the slide and unleashes a magazine full of bullets here. And it's not just that we have Nieves saying he racks the slide. I think you can see it in the video, but you can also, there's also a live round of the same caliber, 40 caliber, that's on the ground. So he's consciously making sure.
It could be that it was loaded. When he racked it, he ejected
I think that's the inference.
The live round.
Right, so he's checking to see, like, maybe he doesn't remember that there's a bullet in the chamber. There was probably a bullet in the chamber, but the point is, he's consciously going out of his way to place his gun, to make his gun ready to kill someone, and then he kills the doorman. That's deliberate premeditation. It's not against the way
Well, in fairness to the defendant's argument and Judge Wilkins' rulings, then he shoots definitely at a downward angle and hits the guy in the knee from very close. You agree that it's clear from the video, they're very close to each other,
They're
correct?
very close. That's
So
true.
it doesn't take much of a marksman at that distance to just lift your arm and hit someone in the chest, correct, or the head. I just want to be fair to the judge below and the defense here. This is not a situation where he was far away at all.
No, he's standing right next to him. You're
Standing
right.
right next to him. So it seems to me like this is a little different. It's a little different from. We don't have a case exactly on point like this in either direction, right? We don't have a case where, unless you can tell us one, where someone is so close to someone that someone with no experience with a weapon could probably hit them in the chest, but yet the wounds are at the knee, and then this strange thing that's harder to, I think the stomach one is much harder for the defendant.
I would agree that I can't point you to a specific case where someone was an extremely poor marksman and only hit someone twice when they shot 8 times. I agree, there's no case that's quite like that, but at the same time that I'm aware of where reduction of the verdict was even an issue. But
Sorry, I want to go back. I think that marksman is just a complete red herring here, right? Like, this is not about whether that's not the issue. The issue is that the argument being made is that there was not premeditation to kill this person because he was extremely close and the gun was not shot straight at him. That's the argument. And we have all these cases saying in the opposite direction, going against defendants and saying, well, clearly there's premeditation because they were super close. And if you shoot someone super close, you clearly intend and you've made a choice to shoot them like in the head or in the chest. And we have all these cases actually using against defendants and saying, this is really good evidence of premeditation to kill, that you raised your gun, you took the seconds to load the gun, you raised it, you shot them in the chest. So this case is different from those because they are very close, and yet the shots aren't in the place that would be expected if the defendant intended to kill.
Well, the second shot's in the stomach, right?
right, he hits him in a vital area. That itself is intent to kill.
I think that is much harder for the defendant. As I said, if this was only the knee, I think it would be a different case. But I don't even think we have a case on point about the knee. Is that correct?
Respectfully, if the defendant had only shot him in the knee, this wouldn't be a homicide case. So we wouldn't really, as a practical matter, yeah, we wouldn't be talking about a 25B issue. This would be like ABDW, SBI, or something.
Did he empty the clip?
Sorry?
Did he empty the clip? He shot 8 times, right? The firearm, did he empty the magazine?
That's not clear. We don't have the gun. The gun wasn't recovered. That might be why he stopped shooting. But that doesn't help the defendant. He just kept on shooting. That's intent to kill. It's premeditation. And the judge, like I said, the judge just doesn't agree with this law. He doesn't agree with Tejeda. That's an abuse of discretion. And I don't think you can save the judge's decision here because it's clearly infected with disagreement with this court's precedent. And the matter about not presenting the second-degree defense, the case that he cites is not at all similar to this case. That case doesn't stand for the proposition that arguing in the alternative a lesser degree of culpability, failing to argue that is a means by itself to reduce the verdict. That lawyer was ineffective in Salazar. And also, the defense in that case was voluntary intoxication, the defense that wasn't fully presented, which actually is a reason to say, oh, it's just second. Mm-hmm. But this fact pattern is a first degree, all day, every day. That's what this case is. He racked the slide and he shot an innocent person to death because he was mad. That's first degree. That's deliberate premeditation. So,
Counsel, you haven't hit the other issue about the compilation. If you could just make sure you hit that.
Yes, I'll briefly address those points. So, this is not a Wordsworth error case. It's not Wordsworth. No, the police aren't pointing to the video and said, that's him, that's the defendant. It's not Wordsworth. I think we all agree it's not Wordsworth. When we're talking about the prosecutor referenced what he expected Riggins to testify to. Riggins didn't end up testifying specifically to the piece of clothing that he actually used to make points of comparison because in the midst of trial, the defense filed a motion to say Riggins shouldn't be allowed to testify to that. So, but I think at the time that the prosecutor said that, the opening statement is on August 20th. The motion in limine that causes the judge to limit the testimony is filed on August 27th. So when the prosecutor said that, this wasn't an issue yet. It becomes an issue in the middle of trial. We comply with the judge's order. The witness does not identify the defendant from the video. I don't think that it's really fair to say that I made a compilation is the practical equivalent of pointing at someone in the video and saying, that's him. And the prosecutor was permitted in closing to marshal the evidence. And it's not opinion testimony to say, we have all this evidence, draw some inferences here because it's the same person. That's not opinion testimony. It's not evidence. The jury are told it's not evidence. And then the other point, I'm sorry, the other point is Judge Wilkins's model limiting instruction on volume 7, page 52. He basically says, don't defer to Riggins at all. It's up to you, the jury, to make this determination. Now, on the Bowden issue, whether or not the door is opened in the opening doesn't really matter because the testimony that Mr. Brown was referring to came in. It was Nieves' statement. So Nieves' statement, the shooter is wearing gray, is in evidence by the time the trial judge decides to let the Flores statement in. And also by that time, the defense attorney has already cross-examined Nieves about certain topics. The judge actually gives the defendant a better standard on admissibility of the anti-Bowden evidence that he's entitled to because he gives him basically the other bad act standard. He says the probative value is not outweighed. The standard really is whether the probative value is substantially outweighed. Whatever. It doesn't really make much of a difference. The judge said it's fair to allow the Commonwealth to rebut what the defense is definitely going to argue now, which is the police are unfairly persecuting my client because I don't know why, but they've botched their investigation. They're focusing on someone wearing blue where their only evidence or where they have significant evidence that the shooter's wearing gray. And the evidence didn't come in substantively. There was a limiting instruction. We must presume that the jury followed their instruction. And I don't think that you can successfully raise an ineffective claim in this posture on direct appeal because it's clearly a tactical decision, but we don't favor ineffective claims being raised in this posture. Unless there's any additional questions, I'd ask that you reinstate the jury's first-degree verdict and otherwise affirm the conviction.